Chapter 6 of the exclusion of oral by documentary evidence, section 91 200. Which one of the following is correct? Section 91 of Indian Evidence Act does not apply to criminal cases. Which one of the observation is correct? Where section 91 does not apply, section 92 does not apply. Where a bill of exchange is drawn in a set of 5, how many of them need to be proved? 1. A give B a receipt for money paid by B. Oral evidence is offered for the payment. The evidence is admissible. A receipt is not contract or grant in respect of which oral evidence is barred. Section 91 and 92 of Indian Evidence Act read be together. These two sections are supplementary to each other. A give B a receipt for money paid by B. Oral evidence is offered to prove the non-payment. The evidence is admissible. A give B a receipt for the payment for money paid by B to A. Oral evidence is offered of the payment. What is the status of evidence under section 91 of Indian Evidence Act? It is admissible. Point out the incorrect statement. D is incorrect. Which one is correct? If a contract is contained in several letters, all letter in which it is contained must be proved. If a contract is contained in a bill of exchange, the bill of exchange must be proved. If a bill of exchange is drawn in a set of 3, one only need to be proved. A agree in writing to sell a horse to B for rupees 1000 or 1500. To show which price was to be given under Indian Evidence Act is evidence cannot be given. Written document must be proved by writing only. This maxim has been incorporated under which one of the following section of Indian Evidence Act? Section 92. Section 91 of Indian Evidence Act applies only to the transaction which under the law must be written, only to the transaction which are reduced into the writing. Which one of the following statement is correct? Section 91 of Indian Evidence Act does not apply to criminal cases. Section 91 of Indian Evidence Act prohibited admission of oral evidence to prove the content of document where the writing is a fact in issue. Indian Evidence Act 1872 A agrees absolutely in writing to pay B rupees 1000 on the 1st March 2010. The fact that at the time of oral agreement was made that money should be not paid till the 31st March cannot be proved. A sell B a horse and verbally warrants him sound. A gives B a paper in this word, bought of A horse for rupees 500. B may prove the verbal warranty. A and B make a contract in writing that B shall sell a house to be paid for one delivery. At the time they make the oral agreement that 3 months credit shall be given to A. Can evidence of oral agreement can be given in the court? Yes, the third party only if he has affected and against A or B. A sell B a horse and verbally warrant him sound. A give B a paper in this word. Bought of A horse for rupees 500. Whether can be proved by verbal warrant? Yes. A agree in writing to sell a horse to B for rupees 1000 or 1500 to show which price was to be given. Oral evidence cannot be given. Which of the following fact can be proved under section 92 of Indian Evidence Act? A entry into the written contract by B to work in certain mind of the property of B on certain term. A said that he would induced to do so by a misrepresentation of B as their value. Evidence Act. An estate called the Rampuri Tea Estate is sold by deed which contain a map of the property sold. The fact that land not included in the map had always been regarded as a part of estate and was meant pass by the deed. The fact is cannot be proved. In which of the cases oral evidence cannot be given? A hired lodging of B and gave B a card on which he wrote room rupees 2000 a month. A in suit wanted to prove verbal agreement that the term included partial board. Mistake referred to the proviso 1 of section 92 of Indian Evidence Act referred to unilateral and mutual mistake. Section 92 of Evidence Act applied to bilateral document. Section 92 of Indian Evidence Act is applicable to the dispute between the party to the instrument only. Oral evidence of a fact invalidating the document is admissible under proviso of Section 92 of Indian Evidence Act. A policy of insurance is affected on good. In slip from Calcutta to London, goods are shipped in a particular ship which has been lost. The fact that particular ship was orally accepted from the policy cannot be proved. A hires lodging of B and gives a card on which is written room rupees 200 a month. A tendered oral evidence proved a verbal agreement that these terms were to be included partially bought. The evidence is admissible. A agreed to sell B his white horse in writing. A has 2 white horses and it became uncertain as to which horse was sold. Here in the document there is a latent ambiguity. Oral evidence is admissible to clarify the language used in the document. When the language is ambiguous or defective on its face. Latent ambiguity in the document means ambiguity of hidden character and for clarifying of which oral evidence may be given. Section 93 of Indian Evidence Act applies to ambiguous patents. For which one of the following document oral evidence cannot be given to remove any ambiguity? Document in reference to existing fact. A and B make a contract in writing that B shall sell a house to be paid for on delivery. At the same time, they make a oral agreement that 3 months credit shall be given to A. Can evidence of oral agreement be given in the court? Yes, by a third party only if he has affected against A or B. The principle stated in section 106 of Indian Evidence Act is an application of the principle of res ipsa loquitur. Chapter 7 of the burden of proof, section 101 to 114a. Consider the following statement. In criminal proceeding, the burden of proof is on prosecution to prove the guilt of the accused. This section of Indian Evidence Act is not on shifting of burden of proof. Section 101. In criminal proceeding, the burden of proof is on the prosecution to prove the guilt of the accused. Which one of the following is correctly matched under Indian Evidence Act? Burden of proof, section 101. In criminal cases, the primary burden to prove a fact is upon prosecution. Burden of proof under section 101 of Indian Evidence Act 1872 never shift. Burden of proof under section 101 of Indian Evidence Act never shift. A desire a court to give a judgment that B shall be punished for a crime which A say has committed. According to Indian Evidence Act, the burden of proof is on A under section 101. The burden of proof means the obligation to prove a fact. This is defined under section 101 of Indian Evidence Act. On whom does the burden of proof lies? On prosecution. In election petition, the burden of proof lies on the person who challenged the election. A kill B. A is charged for murder. In this case, burden of proof is on the state, the B is legal representative. A is tried for the murder of B. He take a plea of self-defense, but the evidence adduced by him is not sufficient to put his case under this exception, although it is enough to create a doubtful whether the charge against him has been positively proved. In this case, A is entitled to acquittal as the prosecution has failed to prove his guilt beyond reasonable doubt. On whom burden of proof lies in criminal cases? Prosecution. A prosecuted B for theft and wishes the court to believe that B admitted the theft to C. Who shall have proved the admission? A. Burden of proof under section 101 of Indian Evidence Act 1872 never shift. Burden of introducing evidence under Section 102 of Indian Evidence Act is constantly shift. The burden of proof in a suit or proceeding lie on that person who would fall if no evidence at all were given on either side. The provision is contained in which section of Indian Evidence Act? Section 102. The burden of proof in a criminal proceeding is upon the prosecution. According to Indian Evidence Act, the burden of proof in a suit or proceeding lie on a person who would fall if no evidence at all were given on the either side. Burden of introducing evidence under Section 102 of Indian Evidence Act is constantly shifts. Under Section 102 of Indian Evidence Act, burden of proof changes continuously. The principle of proving beyond reasonable doubt applies to criminal proceeding only. A prosecuted B for theft and wishes the court to believe that B admitted the theft to C, who must be proved the admission. A accused of murder alleged that by grave and sudden provocation he deprived his power of self-control, and B denies the fact. The burden of proof is on A. To prove the case of alibi, the burden of proof lie on the accused. A wishes to prove dying declaration to B. A must prove B's death. Which section of Indian Evidence Act provided so? Section 104. A wishes to prove a dying declaration by B. The burden of proving that B is dead is on A. A wishes to prove a dying declaration of B. A must prove B's death. Which section of Indian Evidence Act 1872 provides such eventuality? Section 104. A accused of murder alleged that by grave and sudden provocation he was deprived of the power of self-control, on whom the burden of proof lies in above situation to establish grave and sudden provocation. On A. In criminal trial, the onus is on the accused to prove that his case fall in any of the general exception, any of special exception, any of the provisions of any provisions. Section 105 of Indian Evidence Act is intended to apply to which one of the following criminal trial? In a trial, while explaining any circumstances appearing in the evidence against him, an accused of committing murder shall state that due to grave and sudden provocation he was deprived of the power of self-control and thus gave a single lathi blow to A, causing him death. The burden of proving grave and sudden provocation is on the accused. An accused of murder alleged that by grave and sudden provocation he will deprived of the power and self-control under Indian Evidence Act. The burden of proof is on accused. The burden of proving that the case of accused come within any general exception of Indian Penal Code is upon accused. Section 105 of Indian Evidence Act required that the court shall presume that the absence of any circumstances which bring a case within the purview of general exception of Indian Penal Code. Under Indian Evidence Act 1872, In a trial, the burden of proving the plea of insanity is accused lie on the accused. A, accused of murder, alleged that grave and sudden provocation. He was deprived of the power of self-control, on whom the burden of proof lie in the above situation to establish a grave and sudden provocation. On A. A is accused of murder, alleging that grave and sudden provocation. He was deprived of the power of self-control. B denies the fact. The burden of proof is on A. Section 105 of Indian Evidence Act applies to criminal trials. Burden of proving the plea of insanity is on accused. Burden of proving the existence of exceptions to put on the accused by Indian Evidence Act 1872 under Section 105. A is charged with travelling on the railway without a ticket. The burden of proving that he had a ticket is on accused. Which section of Indian Evidence Act related to doctrine of res ipsa lector? Section 106. A is charged with the travelling on the railway without ticket. The burden of proving that A had a ticket is on A. Section 106 of Indian Evidence Act based on the principle of res ipsa lector. A is charged with travelling in the railway without ticket. The burden of proving that he had a ticket is on accused. Ram is charged with travelling on the railway without a ticket. Under Evidence Act, burden of proving that Ram had a ticket is on Ram. Any person in the Section 106 of Indian Evidence Act refer to any party to the suit. A is charged with travelling on the train without ticket. The burden of proving that he had a ticket is on A. A travel while travelling has been asked for a ticket by the ticket checker. The traveller replied that he has purchased the ticket. Ticket checker prosecuted the traveller for travelling without ticket. In the case under which section of Indian Evidence Act prove lie will be determined. Section 106. Which one of the following section of Indian Evidence Act deal with the burden of proving fact, especially within the knowledge? Section 106. Any person in Section 106 of Indian Evidence Act refer to a party to the suit. The presumption in the continuance of life contained in 107 of Evidence Act. The person is presumed to be alive if it is shown that he was alive within 30 years. The presumption of survivorship is contained on Section 107. Section 108 of Indian Evidence Act provided that when a man has not been heard of 7 years by those who would naturally have heard of him if he had been alive, the burden of proving that he is alive shifts on the person who affirms it. The burden of proof regarding continuance of life for 30 years is contained in Section 107 of Evidence Act. The presumption of the continuance of life contained in Section dash of the Evidence Act 107. Civil death may be presumed if it proved that one has been heard for 7 years. Presumption of a death under Section 108 of Indian Evidence Act. The person shown that he has not been heard for the period of 7 years A person shall be deemed to be dead if he remain unheard of 7 years. A man is alive unless nothing has been heard about him for 7 years if it is a presumption of law. In law, a man is presumed to be dead if he is not heard of alive for 7 years. To raise the presumption under Section 108 of Indian Evidence Act as to the death of the person, it must be proved that the person concerned has been given a heard of period of 7 years. When a person has not been heard for 7 years by those who would naturally have heard of him if he had been alive, the burden of proving that such person is alive is shifted to the person who affirms it. The man who has disappeared and remained unheard of 7 years by those who would have naturally heard of him if he was alive, the presumption then arises that he is dead. What shall be the presumption as to time of death of such person? Those who allege that the death should be taken have occurred at a particular time will have to prove that fact. Death may be presumed if it is proved that one has not been heard for 7 years. The presumption that possession of prima facie proof of ownership is provided under which one of the following sections of Indian Evidence Act? Section 101, 110. The good faith of a sale by a client to attorney in the question in the suit brought by the client the burden of proving that good faith of the transaction is on attorney. Section 1011 of Indian Evidence Act speaks of such situation where one person stand in the position of dash to the other person, active confidence. According to Indian Evidence Act, which one of among the following statement is not correct? D is not correct. Which one is correct? When it is shown that person was alive within 13 years, the burden of proving that he is dead is on person who affirms it. When it is shown that the person is not heard for 7 years by those who would naturally have been heard of him if he has been alive, the burden of proving that he is alive is on a person who affirms it. When it is shown that the person in the possession of anything, the burden of proving that he is not the owner of the owner is one of the person who affirms that he is not owner. Which provision of Indian Evidence Act proves that birth during marriage is conclusive proof of legitimacy? 112. 112. Legitimacy of the child born during a valid marriage is a presumption under the provision of which provision of Indian Evidence Act? Section 112. In a case child is born within 280 days of dissolution of marriage, the mother remains unmarried. The presumption of the legitimacy of child under Section 112 arises irrespective of whether the father is alive or dead on the day of child is born. Section 112 of Indian Evidence Act provided for presumption of legitimacy. 112 of the Indian Evidence Act applies when there is a dispute regarding paternity of child. The court draws a presumption of legitimacy when any person is born during the continuance of valid marriage between his mother and any man The presumption is relevant under Section 112 of Indian Evidence Act when there is a dispute relating to paternity of the child. Unless non-access is proved, the presumption of legitimacy of any child born during the continuance of valid marriage between his mother or any man is irrevocable presumption of law. The regular and conclusive presumption of legitimacy of child under Section 12 of Indian Evidence Act can only be rebutable by a non-access of parents. Presumption under Section 112 of Indian Evidence Act raised to when the child is born during the continuance of valid marriage. When the child is born within Section 280 day of dissolution of marriage, the mother remains unmarried. In case of child is born within 280 day of dissolution of marriage, the child remains unmarried. The presumption of legitimacy of child under Section 112 arises irrespective of whether the father is alive or dead on the day of child is born. Legitimacy of child born during the continuance of valid marriage or within 280 days after the dissolution, mother remain unmarried under Section 112 of Evidence Act is conclusive proof. Birth during substance of marriage is conclusive proof of legitimacy. The provision is found on which one of the following sections of Evidence Act? Section 112. If a child is born within 280 days after the dissolution of marriage, the valid marriage, it is conclusive proof of the legitimacy of the child. A child born out of valid marriage can be proved to be legitimate child of the husband if it is born within of its dissolution 280 days. The presumption of legitimacy under Section 112 is presumption of law. The presumption under Section 112 of Indian Evidence Act is relevant when there is a dispute relating to the paternity of the child. Conclusive proof of legitimacy of the child born during the valid marriage is dealt under which section of the Indian Evidence Act of 1872, Section 112. Select the most appropriate statement. A child born during the marriage shall be considered as conclusive proof of legitimacy unless refuted. Section 112 of Indian Evidence Act provides the presumption of legitimacy. In a case of a suicide by a married woman, the court under Section 130A of the Indian Evidence Act may presume that suicide has been abetted by her husband if suicide was committed by the wife within the period of 7 years from the death of her marriage, wife was subjected to cruelty. Section 113A of Indian Evidence Act was added in 1983. The presumption under Section 113A of the Indian Evidence Act pertains to dowry death. Under which section of Indian Evidence Act the presumption as to abatement of suicide by a married woman is dealt? Section 113A. In which section of Indian Evidence Act the presumption as to the abatement of the suicide by a married woman is given? Under Section 113A. In the Indian Evidence Act, the provision on the presumption as to the abatement of suicide by a married woman is contained in section 113A. Presumption as to the abatement to commit a suicide by a married woman has been given under section 113A. The court will presume to abate of suicide by married women when it was shown that she was committed suicide within the period of 7 years of her marriage. The presumption of the dowry death is laid down in section 113b, under which provision of Indian Evidence Act court shall presume the regarding dowry death. 113b. Which section of Indian Evidence Act related to dowry death? Section 113b. Section 113b. The presumption as to the dowry death was added to the Indian Evidence Act in 1986, in which section of Indian Evidence Act presumption as to dowry death is provided? 113b. The following section of Indian Evidence Act is related to the dowry death. 113b. Which one of the following is not a prerequisite of presumption as to the dowry death under section 113b of Indian Evidence Act? Victim had illicit relation with other male person. The presumption as to the dowry death of the women is provided in the Indian Evidence Act under section 113b. Presumption for the dowry death which is mentioned under section 113b of Indian Evidence Act 1872 has been incorporated by the amendment of 1986. Which one of the following section of Indian Evidence Act has been inserted by Dowry Prohibition Amendment Act 1986? 113b. What does the section 113b of Indian Evidence Act deal with? Dowry death. An accused charged under section 302 and 304b of IPC is acquitted of the offence under section 302 of Indian Penal Code. The presumption under section 113b of the Indian Evidence Act is not refuted. Section 113b of Indian Evidence Act contains the provision regarding presumption as to dowry death, which is not a precondition raised an obligatory presumption under section 113b of Indian Evidence Act. The accused is being tried for offence under section 4 of Dowry Prohibition Act. Section 114 of Indian Evidence Act provides for certain presumption of fact. Section 114 of Indian Evidence Act provided a certain presumption of facts. In which one of the following cases the court may presume under section 114? That a man is in the possession of stolen good after the theft is either the thief has been received the good knowing them to be stolen. The judicial and official act has been regularly performed. That the evidence which could be and is not produced would, if produced, in unfavorable to the person withholding it. Example, the police withholding the piece of evidence. Section 114 of Indian Evidence Act provided which one of the following? The court may presume existence of certain fact. Section 114 Illustration G of Indian Evidence Act 1872 refer the presumption as to arising from withholding evidence. Under Section 114 of Indian Evidence Act 1872, court may presume the existence of any fact which, if think likely to be happen regarding being had to be common course of natural event, human conduct, public and private business, all of the above. The court may presume that when the document creating an obligation is in the hand of obligator, the obligation has been discharged. Judicial and official act has not been regularly performed. A bill of exchange accepted or endorsed was accepted and endorsed for the deficient consideration. Which illustration of Section 114 of Indian Evidence Act is based upon the maxim omnia presumptvi writ it solmentary issa acta. Illustration E. What is the provision about an accomplice? His evidence is relevant under Section 114 and 133 of Evidence Act. Section 114 of Indian Evidence Act deals with legal presumptions. Which one of the following fact of the court may presume to exist? When the woman stated in her evidence before the court that she did not consent for sex, child will never lie. A priest will always speak truth. Which one of the following section was not inserted in Indian Evidence Act 1872, Information Technology Act 2002, Section 114A? The prosecution for rape, where sexual intercourse by the accused is proved and the woman stated in her evidence before the court that she did not consent, the court shall presume that she did not consent. Presumption as to the absence of consent in certain prosecution for rape is raised by Section 114 of Indian Evidence Act. Presumption under Section 114A is presumption of fact. In which of the following cases, in the proceeding of rape, when the question is whether it was without the consent of the woman alleged to have been raped, she stated in her evidence that she has not consented, the court shall presume that she did not consent. In all of the above, when the police officer commit rape to a woman in his custody, when a police officer commit rape within the limit of police station to which he is appointed, whoever commit rape of a woman when she was under the 12 year of age. Which one of the following section is not inserted in the Indian Evidence Act of the Information Technology Act 2000, Section 114A? By which amendment Section 114A inserted the Indian Evidence Act 1872? Criminal Law Amendment Act 1983. Section 114A of Indian Evidence Act is related to presumption as to the absence of consent in their prosecution for rape. In a case where document commit rape Doctor commit rape of a woman of 30 years of age under his treatment. The woman says that she did not consent. The court shall presume that she did not consent. Presumption as to the rape is contained in section 114A of Indian Evidence Act. Criminal proceeding, the burden of proof lies on prosecution to prove the guilt of accused beyond reasonable doubt. The man who has disappeared and remained unheard of 7 years by those who had been naturally heard of him, if he was alive, the presumption then arises that he was dead. What shall be the presumption as to the right time of death of such person? Those who allege that death should be taken to have occurred at a particular time will have to prove the fact. The question of mode of proof is the question of produce, but has to be raised at the first opportunity state waived if not raised at first opportunity. The burden of proof is generally lie on prosecution. The burden of proving existence of circumstances bringing the case within the general exception of Indian Penal Code upon the accused person, on whom the burden of proof lies in the criminal proceeding, prosecution. Indian Evidence Act deals privilege as to the right of duly both. XUY for a money due on bond. The execution of the bond is admitted. Y says that it was obtained by fraud, which X deny. The burden of proof is on Y. Burden of proof partially determine the right to begin. Burden of proof is lightened by presumption, admission, estoppel, all of these. Section 101 to 1011 of Indian Evidence Act laid out the provision regarding who is lead evidence to prove the case. This rule is called rule relating to burden of proof. The presumption and interference may be drawn, which may be affirmative or disaffirmative. Which one of the following is correct? Rebutable presumption arises that a man is alive if it's shown that he was alive within 13 years. Rebutable presumption arises that a man is dead if it provided that he has not been heard of 7 years for those who have naturally have been heard him if he had been alive. In which chapter of Indian Evidence Act provisions regarding burden of proof are codified? Chapter 7. Rule as to the burden of proof are rebutable presumption of law. Under section 113A of Indian Evidence Act, court may presume. Under section 113B of Indian Evidence Act, court shall presume. The presumption under section 113A of Indian Evidence Act is not attracted if marriage took place more than 7 years prior to the suicide of women, even if the cruelty is established by the prosecution. A. An illiterate person executed some document in the favor of B. The burden of proof lies on B, in whose favor document has been executed. Burden of proof is adverse possession of it, defendant. in which one of the following statement is incorrect as per the provision of transfer of property? A mere right to sue cannot be transferred. A gift comprised of the both existing future property is void ab initio. Even for a child immediately after marriage, the presumption of legitimacy under Section 112 of Indian Evidence Act would apply. The legislature, which extended the period of the operation of the presumption by 280 days after dissolution of marriage, did not choose to exclude a minimum initial period, the matrimony, for the application of the presumption. Who among the following is liable to explain the injury to accused in the murder trial? None of these. Chapter 8 Estoppel, Section 115 to 117. The principle of promissory estoppel found its root in as an exception to the doctrine of consideration in law of contract, in which one of the following Supreme Court raised a doubt regarding the applicability of doctrine of equitable estoppel beyond Section 115 of Indian Evidence Act. Mandapa versus Chandramanna. A person cannot be denied of a statement previous made. Estoppel. A intentionally and falsely lead B believing that certain land belonged to A and thereby induces B to buy and pay for it. The land afterward became the property of A, and A seek to set aside the sale on the ground that at a time of sale he had no title. A must not allow to prove the want of the title. A new item in the newspaper stated that those who will open industrial unit in Northeast India will exempted from corporate tax for 5 years. X wanted to set up industry, applied to doctors to the industry as well as to the chief secretary of one of the state, and both confirmed the availability of exemption. X proceed with plan. However, the state government withdrew its policy after 1 year. Can X bring estoppel against the state? No. Estoppel cannot be against the state. What is estoppel? Prohibition from proving certain fact. Estoppel is a cause of action in its creates a cause of action. Which one of the following does not figure in Section 115 while dealing with applying the principle of estoppel? Conduct. Which section of Indian Evidence Act founded upon the doctrine laid down in Pickett versus Sear? Section 115. Estoppel can be by attestation, elicited, indeed standing by. Section 115 of Indian Evidence Act 1870 to deal with estoppel. The principle which precluded a person from denying some statement previous made by him is known as estoppel. Estoppel has been defined under Section 115. Doctrine of estoppel means restriction to be make a statement Contrary to the earlier statement, admission A intentionally and falsely led B to believing that plot of land belonged to him. On that basis, he induced B to buy and pay for it. Afterward, the plot of land became the property of A. A bought a suit to set aside the sale in the favor of B on ground that at the time of sale he had no title. In such suit, A cannot be allowed to prove want of his title. Which one of the following is under Indian Evidence Act is not a kind of estoppel? Estoppel by will. Which one is a kind? Estoppel by deed, conduct, record. Which one of the following statement is incorrect in context of estoppel as dealt in section 115 of Indian Evidence Act 1872? The representation must be in writing. The provision relating to estoppel is contained in the Indian Evidence Act is 115, section 115. Which one of the following statements is correct? A representation made by the agent is effectually by proposing of the estoppel and if it has been made by his principal. The case of Sharad Chandra De versus Gopal Chandra Laha is related to which one of the following of the Indian Evidence Act 115? The principle of estoppel is given under which one of the following section of Indian Evidence Act 115? The rule of estoppel is contained in section 115 of Indian Evidence Act 1872. Section 116 of Indian Evidence Act is applicable to immovable property. Under which section of Evidence Act a tenant of immovable property is estoppel for denying a title of landlord to that property? Section 116. Which one of the following statement is correct? There cannot be estoppel when the truth or the matter is known to the both parties. Make the correct statement. Mark the correct statement. The doctrine of estoppel is applied only to civil matter. Estoppel is a rule of evidence. An accomplice is a person who participated in the commission of crime with the charge accused. Doctrine of estoppel is a rule of evidence. Which one of the following is not a case of estoppel? Parvinder Kaur vs. State of Punjab. Estoppel can be by silence, negligence, election. Estoppel should be specifically pleaded. Which one of the following is not an exception to the doctrine of estoppel under Indian Evidence Act 1872? On the question of the fact, Mr. X managed to get admission in MBBS course under the false caste certificate. University took 3 long years to verify and ultimately cancel the admission of X. Can be estoppel work against the university? No, the students had committed fraud himself. In which section of Indian Evidence Act previous estoppel are given? Section 115 to 117. In which case is related to estoppel? Pickett versus Sayre. Doctrine of estoppel is applied to in civil matter. Admission is not a conclusive proof of matter admitted, but they may operate as estoppel. Rule of promissory estoppel is embodied in Evidence Act. doctrine of folding out is applicable to the principle of estoppel.